to him being released on bail and bond. The arguments in those affidavits are clear that he absconded from prison after going to hospital after being sentenced. Therefore, they are looking at the accused person, Governor Sonko, with a view that his character is bad. 2, that he can influence the witnesses. 3, he is, and according to the state's own words, he got the second largest number of votes after President Uhuru Kenyatta. And therefore, he is almost invisible. Therefore, he must be locked in, and therefore the trial must continue until it ends while my Governor Sonko is not available. We have responded clearly from the documents presented to us by the state. Criminal appeal number 80 of 1997 lifted those warrants and settled the matter. And we have produced evidence that Sonko has no any pending matter in Mombasa. 2, we have also raised the question that Sonko's character should not, because of his popularity, it should not be criminalized to be popular. There is no offense for one to be popular. So that if you are popular, whenever the state wants to charge you, they will lock you until your case is over. It has said that Sonko has had 10 previous cases and convictions. We have produced evidence to court that all the 10 cases Sonko was alleged to have been charged, he was acquitted. Therefore, he has no conviction. 3, we have produced evidence that Sonko paid for his fingerprints were taken in December in anticipation that he wanted a certificate of good conduct for him to go to contest for the Nairobi governor's seat after being impeached. He paid 1,020 shillings. He was issued with a receipt. His fingerprints were taken by a police officer and a certificate of good conduct issued on 4th of January 2020. Only 29 days ago, Sonko was cleared by the same DCI. The same DCI saying that Sonko, his character and his antecedents should be the ground to deny him bail. My position as Sonko's advocate and others is that the usage of criminal police power arms against political arguments should come to an end. If Sonko, there was a warrant 20 years ago, what has stopped that warrant from being effected to date, from 2001 to now? Is it that the usage of the police and arms of investigation are the right now channel to be used during this political session we are entering? We have put it to the court very clearly that the DPP under Article 157 cannot control the judiciary because the judiciary is created under Article 161 with the independence to make decisions. They have exercised that power and decided to charge over the matter of 2019. The state might want to do further investigation. The report might be forwarded to the DPP for the DPP to approve or look at that evidence before it makes a decision. It is not a one-off matter, and the procedures are that the state is right on this matter. They must get evidence, they must be ready, because if they arraigned Sonko here on those alleged instances without evidence, we must be given the evidences, statements of the people complaining, and all that is required. So probably the government is doing its work. On our part, I want to assure you that Sonko's team is ready, waiting for as many cases that they'll be brought. Sonko has already flawed the state 10 times. We are ready to floor the state severally because this is one man who has been obedient to the rule of law. He is an ambassador of several international awards of peace, and therefore he will never run away. He will always be available to defend himself.
Member of Parliament, he has been a senator, he has been a governor, And I believe he wants to stand also for political position. He wants to stand again to be a governor or to be a position, a political position. And Your Honor, in all these offices that the governor has held, he has had to seek approvals from the Revenue Department. He has had to seek approvals from IEBC. He has had to seek approvals from the police. How come that now we are being told last minute that this is a criminal? Where was the DPP? Where was the Director of Criminal Investigation? Where were other government officials who were whining with him, eating with him every day, laughing in the newspapers? Why were they not telling us this is a criminal? To have him charged, to do what and so on. Your Honor, that would be morally wrong. And that's why you remember when I started my submission to you, I said to you these words, that you are under duty as a court of law to protect the moral integrity of the criminal process.
He was picked from Mudaiga police station, where he spent the night, taken to CID headquarters, and kept in the car at the parking. Unless it is being suggested that fingerprints are taken at the parking, from that parking he was driven straight to court. 6 in the morning to 10 when he was brought to this court in fanfare. A public officer, contrary to section 132 of the Penal Code. Incitement to violence, there are just 2 charges, not the litany of charges that you have seen. And Your Honor, in this one, the complainant, as we said, but there is something that my learned colleague needed to also alert the court about. While at CID headquarters, and once we had dealt with this, then we were told that there was another complaint by somebody called Christina Pratt. It's important, Your Honor, it's on record. Christina Pratt.
Malaya friend is not telling us who is this, and I cautioned about dropping of names. These names are not just falling by accident. We know where they are going. And if they are courageous enough, they could seek time, reduce this into an affidavit, so that we are able to confront these issues. Now they have just dropped a name, and I know who it is targeted at. They are not telling us, Counsel, please, could you allow me to finish?
I thought you had finished.
They are not telling us what their intention is, and we will not be able to respond to that. That is not a matter of law. He cannot just rise here and tell us, we were told, by who, about what.
Usually, Your Honor, in bail cases, the accused is charged, he makes an application for bail, and then the similar rulings where the same grounds, same documents have been presented before a court of competent jurisdiction and rejected. We emphasize loudly, very loudly, that every time Mr. Sonko is taken to court, it is always a political exercise. That you can't deny us. Every time that happens, the same documents are presented. How do you expect, Your Honor, to do the same thing all the time and expect different results?
That the accused has been looked for since 2000 to date. He has been present from 2001 to yesterday when he presented himself to the DCI. In B35, the last paragraph, a doubtful custom. Dating in general and making a document without authority. The court that lifted that warrant is there. And 6:30 of 1998. So, Your Honor, it is my submission that
those warrants the state wants to talk were lifted. They don't exist. With his political persuasion, he could have been arrested and charged if they were alive. Criminal data. He has 10 previous convictions. And in most cases, he used different names. 10 convictions don't reflect, none of them reflect on certificate of good conduct. Because she cannot decide to say petition number 8 was for
In the same letter, it says that HCCRA number 8001 dated 9201 for the 2 offenses of failing to attend court. Yes. So that is what I'm trying to correct, Your Honor, so that the court should not be misled at any given point that all the matters against the accused person were conclusively dealt with in 8001. Character and antecedents of the accused person can be taken into consideration and can be a ground for the denial of bail or bond. In this instance, Your Honor, and it has been submitted, that there is a matter that is pending before Mombasa, 275 of 01. Your Honor, the file is alive and the file is real. There are victims in these matters. And when Your Honor is retreating to our chambers to make a ruling in respect to the bail application for the accused person, I will invite Your Honor to consider a balance between the rights of the accused person and the rights of the victims in these matters, so that what the prosecution is actually asking.
So let him say and then you interject. Okay.
later. Your Honor, you can make your orders about his bail.
That, Your Honor, in a word, I am not even bothered, like my learned senior said, to go into the nitty-gritty of the so-called...
Say this, counsels and let's take a health break and solve that properly. So,
The main purpose of being here from Nairobi is to see that the governor sleeps at home in his tonight.
okay.
He was in custody.
Yes.
Yeah, we would like him to sleep at home. And I'm not going to waste a lot of time at all. We shall try to be as brief as we can be,
Okay.
so that you can get released.
So it